Your ex doesn't own a place he rents, and you're having trouble finding him. Can you still get divorced? Well, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. The law doesn't require you, unlike TV shows that may suggest otherwise, to actually have somebody hand the papers to your ex. You know why? Because what if your ex evades service? What if your ex doesn't have a place to live? What if your soon-to-be ex is sort of transient? They rent here, they get evicted, they rent somewhere else. What does it mean? You can't get divorced because they can't physically be handed the papers? It's not what it means at all. What it means is like this. The court rules are set up so that you will have an opportunity to give the papers to someone, let them read it, let them participate. But if they choose to evade service and not participate, they can't stop you from getting a divorce. The law requires that every effort be made to try and serve the person. But if you can't serve them, there is a mechanism in the court rules that allows for alternative means of service. Now, there's a procedure. You'd have to demonstrate to the court that traditional methods haven't worked. You'll have to show an affidavit of service, an affidavit of attempts that you've tried to serve them at their last known address and they are there but not answering the door, or they're evading service, or somebody's yelling out that they don't live there anymore, whatever, and then the court will allow other means. But you can still get a full divorce even though the other side is avoiding the issue. Oftentimes the court rules will allow you to post it on the front door without actually serving them. You tack it to the front door. Sometimes you've seen that. Sometimes the court will allow you to post in the multiple public places. You may have seen in the post office or at Kroger. They might have a bulletin board where something is tacked in, a legal notice, and those notices say you've been served. You better do something about it because you're being sued in this court in front of this judge. And so those are methods by which somebody can be notified. When you see those, you ever wonder what they are? I'll tell you what they are. There are people who are avoiding service in most cases, and that's why it's tacked up over there. My point is that the court can let you go and let you get your divorce even if the other side doesn't participate. That's called a judgment of a divorce entered by virtue of default. But I will tell you that a default judgment is just as valid as any other judgment. Can the other side move to set aside the default? Yes, they can. They can ask the court if they are defaulted to set it aside, but they're going to have to show a reason. They're going to have to show good cause and a meritorious defense why the court should set it aside. And some judges will, and some judges won't. So it's going to depend on your particular factual situation. If you have any questions about that, reach out and we'll be glad to help you out.
248-588-3333. 248